class. Welcome to Chapter 6, Module 6, Civil Rights. Civil rights means equal access to society and to the political process without arbitrary discrimination. Disadvantaged groups are those who historically have had little or no economic, social, and political power and who have been singled out for discriminatory treatment in politics and society. The Civil War Amendments and the Civil Rights Movement. In this chapter, we'll cover what are the Civil Rights Amendment, what civil rights challenges faced African Americans, what are de jure and de facto segregation, what did the U.S. Supreme Court decide in Plessy versus Ferguson and Brown versus the Board of Education, what are the Civil Rights and Voting Rights Act, and what is affirmative action. The Civil War Amendments are the three amendments added to the Constitution, the 13th, 14th, and 15th Amendments, after the Civil War to establish the legal status and the rights of the newly freed slaves. The 13th Amendment. In early 1865, the Union's triumph in the Civil War assured Congress passed the 13th Amendment. Quickly ratified by the victorious Union states, it outlawed slavery and involuntary servitude. It authorized Congress to pass laws enforcing the amendment, giving it the power to eradicate not simply slavery, but all badges of servitude. Neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. The 14th Amendment. Abraham Lincoln, assassinated in 1865, was succeeded as president by Andrew Johnson, who pushed for a quick reunion of the North and South. Republicans in Congress feared that the rights of the newly freed slaves would be denied by a return to the old order. Distrusting Johnson, they decided the protections had to be put into the Constitution. Congress enacted the 14th Amendment in 1868 and made its ratification a condition for Southern states' reentry into the Union. The 14th Amendment contains three key clauses. First, anyone born in the United States is a U.S. citizen, and anyone residing in a state is a citizen of that state. Second, it bars states from depriving anyone, whether a citizen or not, of life, liberty, or property without due process of law. It thereby extended the Bill of Rights due process requirement on the federal government to the states. And third, it holds that a state may not deny any person within its jurisdiction the equal protection of the laws. This Equal Protection Clause is the Supreme Court's major instrument for scrutinizing state legislation. It is at the heart of all civil rights. Though the clause was designed to restrict states, the Supreme Court has ruled that it applies to federal government as well. The 15th Amendment. The 15th Amendment, ratified in 1870, bars federal and state governments from infringing on a citizen's right to vote on account of race, color, or previous condition of servitude. The Bill of Rights limited powers of the federal government. The Civil War Amendments expanded them. These amendments created new powers for Congress and the states to support equality. They recognized for the first time a right to vote. Obstructions to the 15th Amendment that were attempted by Southern states. The Grandfather Clause. By the 1890s, the state governments found ways to gut the 15th Amendment's right to vote. It forbade people from voting if their grandfather did not vote. Poll taxes required paying a fee that most black people could not afford. And literacy tests required voters to read and interpret any passage in the state constitution. In 1896, the Supreme Court ruled in Plessy versus Ferguson that there was nothing inherently discriminatory in separating the races. The federal government retreated from the Civil War amendments that protected the civil rights of African Americans. Most African Americans resided in the South, where almost all were disenfranchised and segregated by the end of the 19th century by Jim Crow laws that enforced segregation of public schools, accommodation, transportation, and other public places. Enforcing the 15th Amendment's right to vote proved difficult and costly. Blacks voted in large numbers but faced violence from whites. Vigilante executions of blacks by mobs for alleged or imagined crimes reached new highs. In 1892 alone, 161 lynchings were documented, and many more surely occurred. In 1894, Democrats took charge of the White House and both houses of Congress for the first time since the Civil War. They repealed all federal oversight of elections and delegated enforcement to the states. Plessy versus Ferguson, 1896, introduced the concept of de jure segregation. De jure segregation is the separation of races by law. It received the Supreme Court's blessing in the 1896 case of Plessy versus Ferguson, where the notion of separate but equal was introduced. Racial segregation did not violate equal protection, provided both races were treated equally. Plessy versus Ferguson gave states the green light to so-called Jim Crow laws mandating segregation by law, de jure segregation, on the basis of race. Separate but equal was far from equal in practice. Whites rarely sought access to areas reserved for blacks, which were of inferior quality. Such segregation extended to all areas of social life. At this point in the lecture, I'd like you to click on this link and visit this PBS video from the American Experience on Plessy versus Ferguson. After nearly 50 years of Jim Crow laws in the 1940s, the Supreme Court decisions argued by Thurgood Marshall chipped away at separate but equal. In 1941, a black member of Congress from Chicago was kicked out of a first-class sleeping car when his train entered Arkansas. The court ruled that the Arkansas law enforcing segregation was unconstitutional. In 1944, the court ruled that the 15th Amendment barred Texas from running an all-white primary election. And in 1948, it stopped enforcement of covenants that home buyers signed that said they would not resell their houses to blacks or Jews. Marshall decided to force the justices to address the issue of segregation directly. He brought suit against school facilities for blacks that were physically inferior to those for whites. With the 1954 decision Brown versus the Board of Education, the Supreme Court overturned Plessy versus Ferguson and ruled unanimously that racial segregation in public education violated the Constitution. At this point in the video, I'd like you to watch the video on Brown versus the Board of Education. Only 6% of Southern schools had begun to desegregate by the end of the 1950s. In 1957, Arkansas Governor Orville Faubus, backed by white mobs, mobilized the National Guard to fight a federal court order to desegregate Little Rock's public schools. President Eisenhower took charge of the Arkansas National Guard and called up U.S. troops to enforce the order. The first mass action for civil rights took place in Baton Rouge, Louisiana in 1953. African Americans, led by a Baptist minister, boycotted the city's segregated public buses. Although African Americans provided about 3/4 of the ridership, they had to stand behind an often nearly empty white section. A deal was struck. The city council saved the first 2 rows for whites, but blacks could sit anywhere else as long as they were not in front of the whites. Another bus boycott took place in Montgomery, Alabama. Rosa Parks, a seamstress and an activist in the local NAACP, was arrested in December 1955 after refusing to give up her bus seat to a white man. NAACP leaders sued the city and started a boycott led by a 26-year-old Baptist preacher fresh out of divinity school, Martin Luther King Jr. The boycott lasted 381 days and ended only after the U.S. Supreme Court had declared Montgomery's segregated public transportation unconstitutional. At this point, I'd like you to watch this video about Lyndon Johnson and the Civil Rights Act. In 1964, the Civil Rights Act was passed. At this point in the video, I'd like you to click on the link or go to this link if you're watching the video and watch the film. The Civil Rights Act, Title I barred unequal application of voters' registration requirements. Title II outlawed discrimination in all public accommodations engaged in interstate commerce, such as hotels, restaurants, and theaters. Title III encouraged desegregation of public facilities and authorized the Attorney General to file suits to force desegregation. Title IV authorized the withdrawal of federal funds from public school programs which practice discrimination. Title V expanded the Civil Rights Commission established by the earlier Civil Rights Act of 1957 with additional powers, rules, and procedures. Title VI outlawed discrimination under any program receiving federal assistance. And Title VII established equal employment opportunity in businesses with 25 or more employees. This next video link is Lyndon Johnson's remarks on the signing of the Civil Rights Act of 1964. The Voting Rights Act of 1965. Again, click on this link and you'll get more information about the Voting Rights Act. Or again, copy this link if you're watching the video and bring it up on YouTube. After you're done watching that video, we have another video. Continuing with the Voting Rights Act, there's a second video for you to watch. The Voting Rights Act of 1965 is the most important voting legislation ever enacted by Congress. It requires advance clearance prior to any change in a locale's electoral system, protecting changes in African American voting power. The 1982 amendment provides that an existing electoral arrangement that has racially discriminatory effect also violates the law. The Voting Rights Act was signed into law on August 6, 1965 by President Lyndon Johnson. The act emphasized the 15th Amendment's guarantee of voting for all citizens. It did away with the literacy requirements and provided examiners appointed by the federal government in areas with particular discrimination to ensure equal voting rights. Its effect, Southern African American voter registration increased sharply after the Voting Rights Act of 1965 was passed. According to the U.S. Department of Justice, the Act's role in fulfilling the 14th and 15th Amendments' guarantee of equal voting rights had led it to be considered the single most important piece of civil rights legislation. Victorious in the South, the civil rights movement turned north. Blacks and whites were separated by locality and attended different schools. Separation of the races in the North was by practice more than by law. Such de facto segregation, a separation that occurs by social practice, has proven tougher to address by legal efforts alone. In part due to their perennial interest in vivid, dramatic conflict, the media shifted their focus from nobly suffering victims to fiery, demanding militants. The unity, discipline, and influence of the African American civil rights movement ebbed. Martin Luther King's doctrine of nonviolent resistance was challenged by the rhetoric of Black Muslim leader Malcolm X, who advocated any means necessary to advance equality and promoted SNCC's, Student Nonviolent Coordinating Committee's, new motto, Black Power. In 1968, King was assassinated in Memphis, where he had gone to support the sanitation worker campaign for improved pay and working conditions. Black militancy, amplified in the news, spawned a white backlash. Republican Richard Nixon was elected president in 1968 on a law and order platform that called for slowing down desegregation. The news prominently displayed the dramatic, sometimes violent reaction by whites against the busing of black students to white schools in supposedly liberal northern cities such as Boston. In 1974, the Supreme Court rejected a Detroit plan that required busing across school district lines, and the judicial push for integration slowed. Affirmative action are efforts made or enforced by the government to increase percentages of racial and ethnic minorities and women in higher education and the workplace. The Supreme Court first weighed in on affirmative action in 1978. Alan Bakey, a white applicant, was denied entrance to the medical school of the University of California, Davis. Bakey noted that his test scores were higher than other applicants admitted on a separate track for minorities. He sued, charging reverse discrimination. The court concluded that UC Davis's approach of separating white and minority applicants into two separate groups violated the principle of equal protection. School programs like Harvard's, which considered race as one of many criteria, however, were permissible. A 2003 Supreme Court decision affirmed this position by voiding the undergraduate admission program at the University of Michigan that added points to a candidate's application on the basis of race, but upholding the graduate admission approach that considered race in a less quantitative way. In 2007, the Supreme Court rejected the actions of the Seattle and Louisville school systems to promote racial integration by assigning students to a particular school in order to make the population of each school reflect the city's racial composition. This 5-4 decision by Chief Justice Roberts, leading the court's conservative majority, seemed to prohibit school systems from using race to classify and thus assign students. It did, however, allow the use of other, unspecific race-conscious measures to combat racial segregation. The legacy of slavery and segregation is evident in not only the higher rates of poverty, unemployment, and incarceration, but also the lower life expectancy and educational test scores of African Americans compared to whites. Visitors to the website of the NAACP will find many subjects connected to race, such as police practice of racial profiling of suspects. But the NAACP also deals with issues that disproportionately affect African Americans and that some might think have nothing to do with race. These include a practice that the NAACP labels environmental racism, whereby polluting factories are placed next to poor, largely African American neighborhoods. Other minorities: women, lesbians, gay men, and the disabled. Policies protecting African American civil rights automatically extend to other racial and ethnic minorities. Most prominent of these groups are Latinos, Asian Americans, and Native Americans. They all have civil rights concerns of their own. Latinos of displaced African Americans is the largest minority group in the United States. They are disproportionately foreign-born, young, and poor. Politicians court Latinos as a growing bloc of voters. As a result, Latinos have had some success in pursuing civil rights, such as the use of Spanish in voting and teaching. After Latino groups claimed that voting rights were at risk for citizens not literate in English, the Voting Rights Act was amended to require ballots to be available in languages other than English. And the Supreme Court has ruled that school districts violate the Civil Rights Act of 1964 when students are taught in a language they do not understand. Latino success is not carried over to immigration. Illegal immigrants pose vexing questions in terms of civil rights. If caught, should they be jailed or expelled? Should they be eligible to become citizens? In 2006, Congressman Jim Sensenbrenner, Republican of Wisconsin, introduced legislation to change illegal immigration from a violation of civil law to a felony, and to punish anyone who provides assistance to illegal immigrants, even church ministers. George W. Bush pushed for a less punitive approach that would recognize illegal immigrants as guest workers, but would still not allow them to become citizens. In his 2011 State of the Union address, Barack Obama said, "Now I strongly believe that we should take on once and for all the issue of illegal immigration. I am prepared to work with Republicans and Democrats to protect our borders, enforce our laws, and address the millions of undocumented workers who are now living in the shadows." Asian Americans. World War II brought more discrimination out of an unjustified, if not irrational, fear that some Japanese Americans might be loyal to Japan and thus commit acts of sabotage against the United States. The federal government imposed curfews on them. After President Roosevelt signed Executive Order 9066 in early 1942, roughly 120,000 Japanese Americans, 62% of them U.S. citizens, were forcibly removed from their homes to distant, desolate relocation camps. Ruling toward the end of the war, the Supreme Court did not strike down the internment policy, but it did hold that classifying people by race is unconstitutional. Japanese Americans who had been interred in the camps later pressed for redress. Congress eventually responded with the Civil Liberties Act of 1988, whereby the U.S. government apologized to and compensated camp survivors. Asian Americans have united against discrimination. During the Vietnam era, Asian American students opposing the war highlighted its impact on Asian populations. Instead of slogans such as "Bring the GIs home," they chanted, "Stop killing our Asian brothers and sisters." A dazzling array of Asian American nationalities, religions, and cultures has emerged since 1965, after restrictions on immigration from Asia were removed. Yet, vestiges of discrimination remain. For example, Asian Americans are paid less than their high education might warrant. Native Americans represent many tribes with distinct languages, cultures, and traditions. Nowadays, they obtain protection against discrimination just as members of other racial and ethnic groups do. Specifically, the Indian Civil Rights Act of 1968 guaranteed them many civil rights, including equal protection under the law and due process, freedom of speech, press and assembly, and protection from unreasonable search and seizure, self-incrimination, and double jeopardy. Native American civil rights issues today center on tribal autonomy and self-government on Indian reservations. Thus, some of the provisions of the Bill of Rights, such as separation of church and state, do not apply to tribes. Reservations may also legally discriminate in favor of hiring Native Americans. For much of history, Native Americans residing outside of reservations were in legal limbo, being neither members of self-governing tribal nations nor U.S. citizens. For example, in 1881, John Elk, a Native American living in Omaha, claimed that he was denied equal protection of the laws when he was prevented from voting. The Supreme Court ruled that since he was born to an Indian nation, Elk was not a citizen and could not claim a right to vote. Nowadays, Native Americans living on or outside the reservation vote as any other citizen. Women constitute a majority of the population and of the electorate, but they have never spoken with a unified voice for civil rights, nor have they received the same degree of protection as racial and ethnic minorities. Women's activism arose in the campaign to abolish slavery. Women abolitionists argued that the case against slavery could not be made as long as women did not have political rights as well. In 1848, women and men active in the anti-slavery movement, meeting in Seneca Falls, New York, adopted a Declaration of Sentiments. Emulating the Declaration of Independence, it argued that all men and women are created equal and cataloged repeated injuries and usurpations on the part of man toward woman. After the Civil War, women abolitionists hoped to be rewarded with the vote, but women were not included in the 15th Amendment. In disgust, Susan B. Anthony and Elizabeth Cady Stanton, two prominent and ardent abolitionists, launched an independent women's movement. Anthony drafted a constitutional amendment to guarantee women's right to vote. The right of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Modeled on the 15th Amendment, it was introduced in the Senate in 1878. By 1910, their patience was at an end. They campaigned against members of Congress and picketed the White House. They went to jail and engaged in hunger strikes. Such efforts, widely publicized in the news, eventually paid off in 1920 when the 19th Amendment was added to the Constitution. The second wave of women's rights. With the vote won, the women's movement lost its central focus. Women were split by a proposed Equal Rights Amendment to the Constitution, mandating equal treatment of men and women under the law. It was proposed in 1923 by well-to-do Republican working professional women, but was opposed by women Democrats and labor unions who had won a specific bill for specific ills, minimum wage and maximum hour laws for working women. Meanwhile, women constituted an increasing proportion of voters and made inroads in party activism and holding office. Then came an unexpected breakthrough. Conservative Southern House members, hoping to slow down passage of the 1964 Civil Rights Bill, offered what they deemed frivolous amendments, one of which expanded the act to protect women. Northern and Southern male legislators joined in derision and laughter. The small contingent of congresswomen berated their colleagues and allied with Southern conservatives to pass the amendment. In 1967, women activists reacted by forming the National Organization for Women. Now's first president was Betty Friedan. Her 1963 bestseller, The Feminine Mystique, showed that confining women to the domestic roles of wife and mother squelched opportunities for middle-class educated women. Women's organizations adopted the slogan, "The personal is political." They pointed out that even when men and women in a couple worked outside the home equally, housework and child care fell more heavily on wives, creating a second shift limiting women's opportunity for political activism. By 1970, Democrats and Republicans alike backed the ERA and women's rights. There was no opposition. Who'd be against equal rights for women? Such laws could be far-reaching. Title IX of the Education Act amendments of 1972 outlawing sex discrimination and federally funded educational programs prompted little debate when it was enacted. Now, and other organizations focused on the ERA. It passed by huge bipartisan margins in the House in 1970 and the Senate in 1972. 30 of the 38 states necessary to ratify approved it almost immediately. However, opposition to the ERA, led and generated by conservative women, arose among the general public, including women. While women working outside the home generally favored the ERA to fight job discriminations, housewives feared that the ERA would remove protections for them, such as legal presumptions that women were more eligible than men for alimony after divorce. The public support of the ERA declined because of the fears that it might allow military conscription of women and gay marriage. The political consensus crumbled, and in 1980, the Republican platform opposed ERA for the first time. ERA died in 1982 when the ratification process expired. Although women have made strides towards equality, they still fall behind on important measures. The United States is 22nd among the 30 most developed nations in its proportion of women in Congress. The percentage of female state legislatures and state elective officials is between 20 and 25%. The top 20 occupations of women are the same as they were 50 years ago. They work as secretaries, nurses, and grade school teachers, and in other low-paid white-collar jobs. In 1980, the EEOC, or the Equal Employment Opportunity Commission, defined sexual harassment as unwelcome sexual advances or sexual conduct, verbal or physical, that interferes with a person's performance and creates a hostile work environment. Such discrimination on the basis of sex is barred in the workplace by the Civil Rights Act of 1964 and in colleges and universities that receive federal funds by Title IX. In a series of decisions, the Supreme Court has ruled that employers are responsible for maintaining a harassment-free workplace. Some of the elements of a sexually hostile environment are lewd remarks and uninvited and offensive touching. Schools may be held legally liable if they have tolerated sexual harassment. Therefore, they establish codes and definitions of what is and what is not permissible. The College of William and Mary, for example, sees a power difference between students and teachers and prohibits any and all sexual contact between them. Others, like Williams College, seek to ensure that teachers opt out of any supervisory relationship with a student with whom they are sexually involved. Gay people, lesbians, gay men, bisexual, and transgender individuals are at the forefront of controversial civil rights battles today. Gay people face unique obstacles in attaining civil rights. Unlike race or gender, sexual orientation may or may not be an accident of birth that merits constitutional protection. The gay rights movement is opposed by religious conservatives who see homosexuality as flawed behavior, not as an innate characteristic. Moreover, gay people are not born into a visible community and identity into which they are socialized. A history of ostracism prompts many to conceal their identities. According to many surveys of gay people, they experience discrimination and violence, actual or threatened. Election polls estimate that lesbians, gay men, and bisexuals make up 4% of the voting public. When candidates disagree on gay rights, gays vote by a 3-to-1 margin for the more pro-gay of the two. The anti-communist scare in the early 1950s spilled into worries about sexual perverts in government. Gay people faced harassment from city mayors and police departments pressured to clean up their cities of vice. The first gay rights movement, the small, often secretive Mattachine Society, emerged to respond to these threats. Mattachine's leaders argued that gay people, rather than a justice society, should fight discrimination against them with collective identity and pride. In June 1969, during a police raid at a gay bar in New York City's Greenwich Village, the Stonewall Inn, customers fought back. Street protests and violent outbursts followed. The Stonewall riots were overlooked by network television and at best got only derisive coverage in the back pages of most newspapers. But discussion of the riot and the grievances of gay people blossomed in alternative newspapers such as the Village Voice and emerging weeklies serving gay urban enclaves. By the early 1980s, the gay movement boasted national organizations to gather information, lobby government officials, fund electoral campaigns, and bring test cases to court. The anniversary of the Stonewall riots is marked by gay pride, marches, and celebrations in cities across the country. The gay rights movement's first political efforts were for laws to bar discrimination by sexual orientation in employment, the first of which were enacted in 1971. President Bill Clinton issued an executive order in 1998 banning discrimination on the basis of sexual orientation in federal government employment outside the military. In 1992, presidential candidate Bill Clinton endorsed lifting the ban on gay people serving openly in the military. Clinton said that he would sign an executive order to do so. The news media kept after this issue, which became the top concern of the Clintons' first days in office. The military and key members of Congress launched a public relations campaign against Clinton's stand, highlighted by the media event at which legislators toured cramped submarines and asked sailors on board how they felt about serving with gay people. Clinton ultimately supported a compromise, a don't ask, don't tell policy that had the effect of substantially increasing the number of discharges from the military for homosexuality. The Don't Ask, Don't Tell Repeal Act of 2010. Enacted in December 2010, it established a process for ending the Don't Ask, Don't Tell policy, thus allowing gays, lesbians, and bisexuals to serve openly in the United States Armed Forces. It ended the policy in place since 1993 that allowed them to serve only if they kept their sexual orientation secret and the military did not learn of their sexual orientation. People with disabilities have sought and gained civil rights protections. When society does not accommodate their differences, they view this as discrimination. They have clout because, by U.S. Census estimates, over 19% of the population has some kind of disability. The American with Disabilities Act passed by Congress by a large margin and was signed into law in 1990 by President George H.W. Bush. The act moves away from the medical model by defining disability as including a physical and mental impairment that limits a major life activity. It gives the disabled a right to access to public buildings. It prohibits discrimination in employment against those who, given a reasonable opportunity, could perform the essential function of a job. However, the courts interpreted the law and its definition of disability narrowly, for example, to exclude people with conditions that could be mitigated by a hearing aid or artificial limb, controlled by medication, or were in remission. In response, on September 29, 2008, President Bush signed legislation overturning the Supreme Court's decision. It expanded the definition of disability to cover more physical and mental impairments and made it easier for workers to prove discrimination. So class, that's the end of the lecture for Module 6. There are a number of videos to watch in this module, which I will provide links to and have provided links to both in the lecture notes and in the lecture video.